Losing a loved one is incredibly difficult. During such a heavy emotional time, navigating the complex maze of estate settlement and probate court is often the last thing on your mind, yet it can feel entirely overwhelming. Our goal today is to bring you clarity and support by explaining the vital differences between probate and non-probate assets. Please note that this video provides informational content only and does not constitute legal advice. What exactly is probate? In simple terms, it is the formal legal process of administering a person's estate after they pass away. Think of it as the legal bridge between the deceased person and their heirs. Overseen by a probate court, the process begins with a judge officially validating the deceased person's last will and testament. Next, all of the deceased person's assets must be carefully identified and inventoried. But before heirs receive their share, the estate must settle up by paying off any outstanding debts and final taxes. Only after these obligations are met does the court authorize the distribution of the remaining assets to the rightful heirs. While it can be time-consuming, probate serves a critical purpose. It protects all parties involved, ensuring fairness, settling obligations, and legally transferring wealth under the careful supervision of the justice system. What exactly makes an asset go through probate? The rule of thumb is simple. Probate assets are those owned solely by the deceased person, without a designated beneficiary or joint owner. These are the items that legally require a court's authority to be transferred to heirs. Let's look at some common examples. Individually owned bank accounts are classic probate assets. If your name is the only one on the account without a payable on death designation, the court must step in. The same applies to real estate held in your sole name. Vehicles registered solely under the deceased's name are also subject to probate. And don't forget everyday personal property. Everything from valuable jewelry and antique clocks to ordinary furniture are considered probate assets if left behind. Financial assets like stocks and individual brokerage accounts will also go through probate. The same goes for sole proprietorship business interests. Finally, even life insurance policies can end up in probate if the beneficiary designation is left completely blank. When you leave behind probate assets, your last will and testament is the ultimate guidebook for their distribution. If you've drafted a will, you've likely named an executor. This trusted individual is legally responsible for managing your estate, paying off lingering debts, and ensuring your assets are distributed exactly as you wished. But what happens if you pass away without a will? This is known as dying intestate. In these cases, the probate court steps in, and your state's intestacy laws take over to determine who gets what, stripping away your personal control over your assets. Every state has its own unique rulebook. Take New York, for example. If you pass away leaving behind a spouse and children, New York intestacy law dictates that your spouse inherits the first $50,000 of your intestate property, plus half of the remaining balance. The rest is divided equally among your children. Now let us shift to the fast lane. Non-probate assets transfer automatically to your loved ones upon your passing, completely bypassing the probate court. Thanks to built-in transfer mechanisms, they never need a judge's approval. What falls into this category? First is jointly owned property with the right of survivorship. If you own a home with your spouse, full ownership automatically transfers to them. Life insurance is another major one. If you have explicitly named a beneficiary, the payout goes directly to them. Retirement accounts, like a 401k or an IRA, work the exact same way. The funds pass immediately to the person you designated. You can also use pay on death or POD designations for your regular checking and savings accounts, and transfer on death registrations for your brokerage accounts and individual stocks. Finally, there are living trusts. Any asset held within a living trust avoids probate entirely. It acts as a protective vault for your wealth, ensuring their property is distributed privately, efficiently, and exactly as you intended. When it comes to estate planning, many assume their will is the ultimate authority. However, beneficiary designations actually hold more power and will override whatever is written in your will. For example, if your will states that your current spouse inherits everything, but you never updated your IRA beneficiary designation after a divorce, your ex-spouse will likely inherit that IRA. This is why keeping designations current is absolutely critical. Another incredibly powerful tool is a living trust. A living trust is a legal arrangement where you transfer ownership of your assets into the trust while you are still alive. Because the trust, not you, technically owns these assets, they completely bypass the probate process upon your passing. Setting it up involves drafting the document, transferring your assets to fund the trust, and then managing them. Upon your death, the assets are distributed privately, directly, and without court interference, giving you ultimate control and peace of mind. Why does the distinction between probate and non-probate assets matter? It comes down to 4 key factors: time, cost, privacy, and control. Probate can tie up assets for months or years, racking up hefty court and attorney fees. Non-probate assets bypass this entirely, transferring directly to your beneficiaries in weeks, saving significant time and money. Privacy is another crucial factor. Because probate is a public legal proceeding, your will and asset inventory become a matter of public record. Non-probate transfers, however, keep your family's financial affairs completely private and secure. Finally, there's control. Relying on probate means your loved ones must navigate a complex legal maze subject to court oversight. Using non-probate mechanisms ensures you maintain direct, absolute control over exactly who inherits your assets, free from court interference. To take control of your estate, a proactive strategy is essential. Start by regularly reviewing your beneficiary designations. Make it an annual habit, and always update them following major life events like marriage, divorce, or the birth of a child. Next, pay close attention to how your property is titled. Strategic titling, like joint ownership with right of survivorship or utilizing a living trust, directly dictates if those assets bypass probate or not. Because the rules are complex and vary by state, consulting an estate planning attorney is invaluable. They ensure your wishes are honored and your family is protected. Find your local probate court and more resources at probateus.com. Thank you for joining us today to unravel the complexities of probate. As a quick recap, probate assets are typically held in sole ownership and must go through the court process. Meanwhile, non-probate assets, like those with designated beneficiaries or joint ownership, bypass the court entirely, saving your loved ones valuable time and stress. Proper estate planning protects your legacy and provides peace of mind. Because every situation is unique, we strongly recommend seeking professional legal advice tailored to your needs. For more helpful resources and to easily locate probate courts in your area, please visit probateus.com. If you found this video helpful, please like, subscribe, and share it with anyone who might benefit. Have a question? Leave a comment below. We would love to hear from you. Take care, and thank you for watching.